And good afternoon. I'm going to go ahead and call this session of the City of Bonney Lake Hearing Examiner to order. For the record, today is March 20th, 2023 at 1 p.m. We have two items on the agenda this afternoon, and they are very similar in nature. In both instances, they involve the city essentially requesting, I think, apparently I'll get more information, but in both instances, the city is seeking a determination by me that the buildings in question, the structures in question are uninhabitable and unfit to be dwelled in. This is part of the due process that ultimately would occur along the way. But this is my specific role as the hearing examiner here in Bonney Lake is to ensure, that process has occurred according to provisions of the municipal code. And excuse me, I apologize. And ultimately, today, my role will be to collect evidence in the form of exhibits and testimony to determine whether the city has proven by a preponderance of the evidence. I believe that's the standard. I didn't have time to look this morning. I'll make sure that our both sides have an opportunity to address that, but typically that would be the case. But ensure the city has proven by preponderance that these issues do exist and determine what it is that they would like as next steps. That's my role, and to that end, all witnesses will be testifying under oath or affirmation, and I will sort of address admitting exhibits into the record. I did have some materials that were submitted in advance of the hearing, none specifically from the structure property owners, as it were, in either case, but information that was provided by the city. So we'll discuss that when we get started. And then typically we would hear from the city, and they would, have an opportunity to make their case and call their witnesses, and the other side would have an opportunity to cross-examine any witnesses and ask questions. I have an opportunity to ask questions and interrupt and be rude if I so desire. And sometimes I do, but these matters do appear to be somewhat straightforward, and we don't have any other participants. So I have a feeling these will go quickly, but we will make sure to check whether anyone joins us, because if so, the property owners would have an opportunity to participate. So with that, we'll go ahead and I think get started. And Andrew Reeves, I introduced myself by name, I hope, sorry. Yeah, okay, sorry. Been a little flustered today because I wasn't exactly sure what was happening, but we're going to work it out. I apologize, but anyways, we'll get started, and I think I'll have the attorney that is working on behalf of the city introduce himself at the outset and maybe give us just any procedural matters you wanted to address. But essentially, one of the first things after you and I talk about procedural matters is I typically would ask if anyone has any objections to the exhibits you would like admitted into the record. I suspect nobody will have objections because there's nobody here, but please introduce yourself if you could, and if you could just spell your name. I'm not going to swear you in because we don't swear in attorneys. Sometimes they get sworn at, but they will not be providing testimony, nor will I. But you will have obviously an opportunity to make an argument and call witnesses. So thank you for being here.
Thank you. Jackson Marchant of the law firm Inslee Best, Dozie and Ryder, here for the city of Bonney Lake. And
you don't need to spell the entire law firm out, which changes names every year or two. But if you could just slowly spell your name just for the audio.
Sure. Jackson Marchant.
Great. Thank you so much, Attorney Marchant. And with that, are there any procedural matters? And by the way, I should have stated the intent today was we were going to start with what the cash matters. So essentially, there are two items And the first item is for parcel number 30370000950 related to property at 20616 Church Lake Drive East, owned by Melissa Cash. So my intent was to start with that. And so do you have any specific procedural matters related to that particular, this particular matter?
So, Your Honor, with this matter, we were initially here seeking a determination that the property was unfit for human habitation because it was without running water and adequate sanitary facilities. Operative word there is was without running water. Ms. Wilkinson can testify about communications that Ms. Cash made with the city and the fact that Ms. Cash has paid her water bill and water is being turned back on. So to the extent that the city was seeking declaration that the property was unfit for human habitation, it is no longer doing so. However, the city is still seeking to because the city has incurred costs in enforcing the code, which it seeks to assess against the real property. That's sort of what we're going to talk about today, rather than the argument declaring for a declaration that the property is unfit for human habitation.
Okay, so essentially, there's been some compliance. I do not want to put words in anyone's mouth, but it sounds as if there's at least been communication between the city and the property owner, and there's, things are moving in the right direction on some level, and so. But to that end, we will hear testimony here in a sec. Starting out, I did receive some materials essentially prepared by city staff. I don't have exhibit numbers necessarily. I mean, I have attachments to the brief that you had prepared, the complaint. But can you maybe just very quickly walk me through what it is that was provided in the record, and then so far that I
Sure.
have?
So the record that we're going to rely on today for this matter is the exhibits that are attached to that complaint.
Okay, so the complaint starts on PDF 3 for me, page 3 of the PDF, one page of, first page, obviously, the complaint. And then at the end of the complaint, we've got several exhibits attached. And these include the notice of violation that was issued on August 25th, 2022. And that had photos as part of it. And then I believe we've got the notice of civil penalty is exhibit 2. And then at one point earlier in the process, I believe the city had provided me with a notice of, what was it called? Apologies. Mailed unfit dwelling notice, and I think this is a different document that is not yet in the record.
And Your Honor, I believe the mailed unfit dwelling notice is, and Ms. Wilkinson might be able to testify and provide more information about this. I believe that's a courtesy that the city provides. Our position is that the notice of violation and the notice of civil penalty and the complaint are, sort of speak for themselves and contain the requisite record to establish by a preponderance of the evidence that the property was unfit for human habitation.
Sure. I mean, I can't unsee what I've seen, and maybe I'll ask Ms. Wilkinson about that. But at a minimum, I would certainly, accept the 2 exhibits you attached, which included, the NOV and the. Sorry, now I've got the wrong thing open.
Notice of civil penalty as well.
Thank you. The NOV and the NOCP, but.
And briefly, Your Honor, I did want to address something really quick that you addressed earlier. The standard for this hearing is preponderance of the evidence pursuant to Bonney Lake Municipal Code 14.130.120. For the
Thank you.
record.
I thought I was right. I just want I would didn't didn't want to mess that one up. And okay, so that said, though, there's a couple other things too. To the extent that there's some receipts, there's some other information that are included. I'd prefer to get everything in exhibit number so that it's more clearly identified. I think those show, the sort of some of the costs and how notice was provided, I believe. But I'll, let you ask questions of our code enforcement officer. But that said, we can work on exhibit numbers shortly, but we do not have any objections. No one's joined us, and I see no reason why the documents, that have been provided to me would not all be appropriate to include in the record moving forward. So though we haven't worked out the exact exhibit numbers, I will include all of this information would be the plan. And with that, anything else you wanted to cover before you move to your witness?
I don't believe so, Your Honor. And sorry, I'm a former prosecutor, so that Your Honor is the one I default to. But
the most respect I'm going to get all week. I'll tell you that much. So.
Okay. Do you want a citation to the relevant provisions of the Bonney Lake Municipal Code before we get into testimony, or?
Sure. I mean, I guess it would probably be helpful to just very briefly. I don't need you to, read the entirety of what you've done.
Certainly.
I will read it very closely, and I like to think I read well and I have a certain level of understanding of the law, but maybe just touch on the sort of, facts. Well, and this one is a little unique, so that might be helpful too, to the extent that I know that things have changed or shifted since, this began, and just recently. So I guess if anything, I don't want to dictate the order you go in, because again, this is going to be a little strange. So if you think it's more helpful to hear from code enforcement first, that's fine. I would ultimately, like to have an argument as to sort of, what you want me to do and what the justification is. Sure. under the municipal code, because it's less, what are we tying it to if there's been some kind of compliance, and I haven't made up my mind one way or the other, but that would be a helpful argument. But
sure,
if factually it'd be easier to start with your witness, fine with me. I'll let you tell the story.
I do. I'll just kind of put out a roadmap to start with, though. So while we did initially seek declaration of the property as unfit for human habitation, under BLMC 14.130, one moment, 0.160, due to the lack of running water, the defendant has turned the water back on as far as we know. So we are now seeking to recover costs that the city incurred enforcing the code. And we're seeking to do that pursuant to Bonney Lake Municipal Code 14.130.120, 14.130.160, and RCW 35.80.030 1H. So with that, what we're also looking to do is to have a determination that the notice of violation, the notice of civil penalty, were properly served pursuant to the Bonney Lake Municipal Code, and then a finding that the city is entitled to the cost of enforcements as well as reasonable attorney's fees.
Okay. I understand the argument, and so with that, I'll let you move on to your witness, and I point out that unlike often would occur in, say, criminal law proceeding. Narrative responses from the witness is fine. I know that that's going to be a challenge for a prosecutor to, they don't want you to say more than you ought to say, or, well, I guess defense attorneys are really the ones that don't want that. But I'm not going to tell you how to do your job, Attorney Garza, but just letting you know that we are not strictly bound by the rules of court. It is formal. It's important. We do address due process. We take it seriously, but well, you're not going to hear any objections because you're the only attorney for one in the room, I think. But I'm not going to, we can cross those bridges when they come. But my point is, I think our code enforcement officer probably can explain the situation if you give her enough leeway to talk for a few minutes. My point.
and at this point, just for clarification, are the complaint and its exhibits part of the record?
They are. I'm gonna need some clarification ultimately on what some of these things are, and perhaps you can walk through that. I don't need it blow by blow, but one of these is so there's receipts. Someone can explain what those are. I didn't have a chance to look closely at any of this. Procedurally today, but I'm confident that someone will be able to explain it to me. So with that, and if anyone is off, if anyone has a question about process, let me know. This is new for this group of folks in Bonney Lake working together, and we will make sure that even if we're bumbling along, we make a very clear record, and that everything is properly admitted. So the intent is that the recorded documents is titled 2023-0213, I believe that being the date in a certain format related to the cash matter. Everything in that PDF so far has been admitted, and then the one additional item I figured we would include as well would be the courtesy letter that we discussed. So that's the universe that I have at this moment. So with that, are we ready to get your witness sworn in?
We are.
Excellent. Okay, I'm going to have you raise your hand. Do you swear or affirm to tell the truth in the testimony you give here today?
I do.
Thank you. And could you just state and spell your name for the audio?
Shaylee Wilkinson, SHAILEYWILKINSON.
Okay, and your role here at the city?
Code enforcement officer.
Thank you. And so with that, I will let Attorney Martian ask you some questions. And I note that we don't need to go into an extensive list of questions on her background and all of that. Minor details are fine, but
certainly.
With that.
All right, Ms. Wilkinson. So I am going to ask you to turn your attention to the August 25th, 2022 notice of violation.
Okay.
And can you tell the court how that was, or rather tell the hearing examiner, how that was served on the defendant?
Yes, this was served via first class mail per Bonney Lake Municipal Code 14.130.050, option number 2, service by mail.
Okay. And after that was served on the defendant, did the city receive any communication from her regarding the notice of violation?
No, we did not hear anything from anybody regarding that property after that notice was sent.
Okay. And then moving on to, well, I guess before we move on, can you tell us a little bit about the contents of that notice of violation, what the city was concerned with, and sort of why we're here?
Yeah, there are several violations listed in it. The one we're here for today would be for the inadequate sanitary facilities, which is in the International Property Maintenance Code, 502.1, which our code adopts, in chapter 15. I don't have it listed on here. Oh no, I do. Bonney Lake Municipal Code 15.04.020.G adopts the International Property Maintenance Code, requiring running water for adequate sanitary facilities. Do you want me to list all of the concerns or just?
That's okay since it's part of the record.
Okay.
Let's move on to Exhibit 2 to the complaint, which is the notice of civil penalty. And
Yeah,
can you tell me the date on that document?
October 5th, 2022 is when
And
it was
how
sent out
how was it sent out?
via first class mail, according to BLMC 14.030.050, option number 2.
And these were both this notice of civil penalty and the notice of violation were both sent to Melissa Cash, correct?
At 20616 Church Lake Drive East.
In Bonney Lake. And what is the amount for the civil penalty assessed in that document?
$2,000. So it's $1,000 for each day that the city documents the violation.
Okay. And after issuing that notice of civil penalty, did the city receive any communication from the defendant, property owner, regarding that document?
No.
Okay. And then, are you familiar with the complaint in this matter?
Yes. The complaint from. Sorry,
Whoa.
can you specify?
Sorry. I didn't go anywhere, did I?
No, you're good.
Okay, thank you. I'm trying to have two screens where I can look at things, and so I apologize. I didn't mean to interrupt. I was terrified something bad happened.
No worries.
I interrupted. Please continue.
So, Ms. Wilkinson, you're familiar with the complaint the city filed in this matter?
Yes. Yes, sir.
And can you describe what the city did to serve that complaint on the defendant?
Yeah, so February 13th, all the documents were reported onto the title. And then on February 14th, the notice of hearing, along with the notice of violation and the notice of civil penalty, posted on the site, which is per BLMC 14.130.050, option number 3, in addition to option number 2, which is service by mail. And we, in addition to that, went above and beyond and sent it certified mail.
Okay. And do you have a receipt of that certified mailing?
Not on me, but I believe it's on me. I believe it's in.
Sorry, I didn't catch all of that.
I don't have the receipt in front of me, but I believe I do have it.
Okay. And so the complaint was served by posting on the property on the 13th, you said, of February?
14th. It was
14th
posted on the
February.
14th. It was recorded to title on February 13th.
And it was recorded to title with Pierce County Auditor. Okay.
Yes.
And can you describe what sort of in general terms? I mean, we have the notice of violation, we have the notice of civil penalty, and the complaint. Can you describe kind of in general terms what the city has done to enforce the city code in this case? You can talk about visits to the property, anything else that we need to know that the city has, any other time the city has spent in enforcing this.
Yeah, so we originally received the complaint regarding the property, the several violations going on. And during my investigation of that, discovered that they also do not have a license. It was verified through our finance department. And that was how we came up with the $2,000 for the civil penalties. It's for each day that we document it. So I verify it first, and then I send the notice of violation, When I receive no response and there's no action taken within the 30 days provided in the notice of violation, then I go recheck everything, make sure that nothing's been abated and nobody had, like, to verify that nobody had contact with me but didn't just fake the violations and say nothing. So there's 2 visits to the property. In addition to that, I went out when we posted it. So that would be another $1,000 for that visit to the property as well.
Okay. And that you've also spoken with the city attorneys and such as me or Ms. Robertson, Mr. Chambers.
Several times.
Okay.
Yeah.
And can you tell us about the condition of the property right now? Is water restored?
Yes. So as of Friday afternoon, March 17th, they paid their utility bill in full, and our Public Works Department went out.
Sorry, you trailed off a little bit there.
Oh, sorry. As of March 17th, 2023, in the afternoon, Melissa Cash paid her utility bill in full, and our Public Works Department went and turned the water back on Friday evening, the 17th.
Okay. And I don't have any further questions. Your Honor, if you have questions, I suppose now would be a good time.
Sure. I guess just to the extent of, to be clear, so first we had a courtesy letter, correct? And I'm going to include that in the record, was my intent.
So on that, we decided as a city to send the courtesy letter on these 2 particular properties, or this particular property. There was some mailing issues and it never actually went out. It's not required by our code, so it did not stop our process, and going forward we will be sending them. But for this one, it's not relevant.
Okay, so that changes my intent on having that included in the record to the extent that it didn't go out. So I will not have that. Any objection to me not including that. I didn't realize that was the case. I fully understand that you're saying it's not required. It's a courtesy. But that courtesy letter, or even just from a process standpoint in the future, that's specific to the hearing on the unfit, uninhabitable structure, right? So it's
correct.
Okay, so essentially you've already had a code enforcement process, in terms of, the city's been attempting to gain compliance with the municipal code for various reasons, mostly nuisance type reasons, or failure to keep things in working order under the International Property Code, Maintenance Code, those types of fire code, building code. But that's the beginning of the process in a way, and then
no.
Wait, sorry.
Sorry. So that letter would come after we've done the whole code enforcement process, to let them know that we are taking it to the hearing examiner to have it deemed unfit for human habitation.
Right. Sorry. I was moving past the letter. I was going back in time, saying,
okay, sorry.
The way the process started was, there was a complaint of some kind, usually correct by you don't go out unless something's glaring and actively try to do this, but someone had complained, and then that, there was a process in place where someone could have, well, I guess really quickly, is the process such that there isn't automatically a hearing for code enforcement, correct? They would have to appeal the NOV. Is that right?
Correct. They have 15 days to appeal the notice of violation.
And no one did so in this case. And then moving beyond that, the notice of civil penalty went out.
Mhm.
And that also was appealable,
Correct.
and they didn't do that.
Correct.
Then later, that's when you ended up, getting the courtesy letter. Normally would go out around, at some point after that. And
Correct.
then if still nothing, then that's when you get to this what one would think of as the end of the process
Right.
potentially. Am I understanding that how that works?
Yes.
Okay, thank you. Um, and but that said, so whether you or Attorney Marchand are the better person, I doesn't makes no difference to me. I guess ultimately, I'm trying to understand. So what ultimately is the goal today? I mean, is it simply just city is hoping to get compensation back for having to go through this process? I mean, am I looking? Is it you, Attorney Marchand, that's going to
Yes,
answer that?
and that's essentially right. It's uh, between posting the notice of violation, not hearing anything back, going back again, posting the notice of civil penalty, engaging, working with the city attorney to prepare a complaint for the matter, and then serve that the time that the city is paying me to be here, and other attorneys at my firm to work on the matter. Um, our position is that the city has taken actions to enforce the code, even though we're no longer seeking the determination that the property is unfit for human habitation. The city has still incurred expenses to bring the uh, to prosecute the case essentially.
Sure.
So what we're looking for is um, and
I,
and
I don't know what's happening. Is anything weird on your end happening,
I
or
think we have lost Mr. Sullivan,
Yeah, he told me he's got to drop off. He's got another meeting to go into.
that's okay? That's
but I
fine.
think we have everybody we
Wanted to
need.
make sure
Yeah,
I
we're
didn't
good.
lose anyone, or all right. Well, I mean, I didn't that nobody got booted.
No.
Mhm.
Sorry, I'm afraid that someone is logging into an account on another device through my network that could cause problems. I'm hoping it doesn't. I'm going to pause you all for 1 second just to make
Sure.
sure. And okay, I think we're okay. Okay, please continue. My apologies.
Sure. So yeah, I think I've sort of laid out what we're hoping to achieve here. Um, there's still an outstanding civil penalty of $2,000. I would the city would ask to submit a supplemental affidavit to show that the fees its attorneys charged on this matter were reasonable. And so today, I think what we're asking for is um, an order
What
for the defendant to pay the costs of abatement, including reasonable attorney's fees, to be assessed against the property as a tax pursuant to RCW 35.80.030 and Bonney Lake Municipal Code 14.130.120 and 160.
Thank you. I was going to say I certainly appreciate hearing this, but I think, and I'm not trying to make a ton of additional work for you, Attorney Marchand, but could you basically just give me something very straightforward in writing as well that just says, in light of, A, B, and C at this point, this is what the city, is seeking at the, because it was a curveball. That was certainly not what I was thinking I was going to hear when we started, and it just, in my experience, helpful to have that in writing as well, so it's very clear and should be provided to the other party as well. But
And Your Honor, in the complaint, I believe it is.
I think most of the info's there. What I mean is, again, I'm not trying to make you do a ton of work. Even if all you need to do is cut and paste, just so that it's clearly taken out, so there's no confusion when down the road someone else gets involved. Everyone knows exactly kind of what the process was, and I'll make sure my order's clear. But
Sure.
I certainly know that in some, these experiences, you start with an NOV that might have 28 things, and then by the time you get toward the end, it's really only one or two things. So, this was even more unique to the extent that it all kind of changed in the last day or two, I assume. But
Sure.
So again, I don't need a full brief, nothing, just very kind of straightforward, just,
An affidavit.
Yeah, well, even just it. Yeah, I mean, you could have a couple paragraphs that you write with an affidavit. Actually, I don't need the affidavit to the extent that she just testified. I'm just saying,
Sure.
just so it's very clear on what is being sought. To the
Okay.
extent that I'm happy to make a ruling, I gotta, I'll look more closely, obviously, at the code, but make sure I didn't misunderstand, and make sure you made your argument legally. But in terms of the burden of proof as to what has happened, I think it's been clearly delineated as to, kind of A, B, and C in
Okay.
terms of what happened factually. So really just, I'll just have to think through kind of, the money side of it, as it were, which is a legal issue. So I think code enforcement's done what they need to do. I just want the tiniest little thing on exactly what you were hoping for in terms of an order for me.
Sure. Yeah, I can provide that.
Yeah. Okay, and just to be sure, nobody's joined us, correct? That we're aware of. Doesn't look like it. Okay.
Yes.
Wait, yes meaning no?
Oh, sorry, just us. Sorry.
Just us. Oh, okay.
Just us.
Just us. All right. So that first matter, then I believe we can close the record on, to the extent that, Attorney Marchand, I suspect it won't take you long, but anytime in the next day or two would be fine with me.
Sure.
If you can just provide that to city staff, they'll make sure I get it, but
Okay.
also make sure, the other party gets it, just
Right.
so folks are kept in the loop. But yeah, I'm aware that your complaint or brief or whatever, however we're calling this, lays everything out. But like I said, there's too much information at this point. And I just want to make sure nobody gets confused further down the road.
Okay.
Okay. So with that, you had anything else on this first matter?
Nothing further on this matter.
Okay. And like I said, we have no one that's joined us. So no cross-examination. So yeah, I think in terms of evidence, we can close the record, and I will, once I get that final, very, very, very short distillation of what the city is seeking in terms of an order from me legally, I will produce something to that effect. And I think with that, we can move to the second matter,
Okay.
Which I don't know. Is it more exciting, less exciting? We'll find out. But from what I have, the second matter is the Gaylor matter, and that relates to property at, let's see, is it I got two addresses, but I think it's 20002 77th Street, Court East, is the property owned by Carl Gaylor, and very similar issues to the extent of what we dealt with in the first go round, and in terms of documents very similar to the extent that we've got the sort of brief or complaint, as it were. We've got the NOV from let's see, 6/9/22, and then we've got, which has photos. We've got the additional NOV 8/31/22, which I'll let folks explain, has more photos. Working our way through, and then the notice of civil penalty from October, and then same as last time, I did have that additional document, and we'll let our code enforcement officer tell us whether or not that went out. I suspect it probably didn't, but at least the documents that are here, I intend on including in the record. And with that, we don't need to re-swear anyone in. You were already sworn in terms of code enforcement, and nobody's joined us, but we are now on the second item on the agenda. So with that, Attorney Marchant, if you want to get started, that'd be great.
Right. And for the record, Jackson Marchant, Jackson Marchant of the law firm Inslee Best for the city of Bonney Lake. Your Honor, this matter, similar, identical posture to the last matter. Ms. Wilkinson can speak to the fact that the water is going to be turned on today. In all likelihood, the defendant paid his water bill, so the city is here not seeking any more for a finding that the property is unfit for human habitation. What we are seeking is determination that the notices of violation and notice of civil penalty and complaint were properly filed and served on the defendant, as well as to recover the costs of enforcement, including reasonable attorney's fees, for bringing this action to be assessed as a tax against the property subject to the action.
Okay. So, I apologize for interrupting, but yes, not what I was expecting, and that's but
nor I, Your Honor.
But I'm sure that our code enforcement officer can attest to the concept that the goal of these things is compliance and achieving compliance, not taking people's homes away or whatnot. So, not to put words in anyone's mouth, but that has certainly been my experience in the past. Haven't had a ton of these in Bonney Lake yet, but in a lot of jurisdictions. So I didn't mean to interrupt you, but I was just, not the day I thought I was going to have, which is fine. But with that, anything further you wanted to add? I think in terms of, again, you pointed out the posture. If in fact, never mind. I was going to say you could probably do one for both, but don't. Let's just keep them totally separate, as
Sure.
you know, the smarter move. But I think you made the sort of point of what my authority would be and why we're sort of here in terms of, legally speaking, what the city is seeking, despite there being sort of some achievements of compliance.
Sure.
I think you've made that point already, and you don't need to fully repeat it from before in terms of bigger picture. But with that, if you had specific questions or questions specific to this property that you would like our code enforcement officer to respond to, now would be perfect.
Certainly, and again, it's similar roadmap to before. I'm going to ask about the method of service of the relevant documents, and generally the costs that the city incurred in bringing the action and enforcing the code. So, I'll just point out for the record, this is the standard here is preponderance of the evidence, and we are looking to Bonney Lake Municipal Code provisions 14.130.120, 14.130.160, and RCW 35.80.030 for costs of abatement. We're looking at Bonney Lake Municipal Code 14.130.050 for method of service. And with that, Ms. Wilkinson, you've been previously sworn as a code enforcement officer with the City of Bonney Lake. Are you familiar with the code enforcement case regarding 20002 77th Street Court East in Bonney Lake?
Yes, I am.
All right. And if you'll turn your attention to Exhibit 1 of the complaint, can you tell, do you recognize that?
Yes, I do.
And how do you recognize it?
It is a notice of violation that I sent to Carl Gaylor at his mailing address in Auburn, as well as to the current resident residing at 20002 77th Street Court East on June 29th of 2022. It was postage prepaid first class mail per Bonney Lake Municipal Code 14.130.050 option 2. And I received no response after sending that.
All right. And you said the date on it's June 29th, 2022, correct?
Correct. Yes.
And then moving on to, there's some pictures. Moving on to Exhibit 2 to the complaint. Do you recognize this?
Yes. So this is a second notice of violation that I sent out to the same two addresses, the address Carl Gaylor in Auburn and to whoever the current resident was at the 77th Street Court East on August 31st, 2022. The reason for the second notice of violation was the water was shut off between the time of the first notice of violation and the second notice of violation. So while they were in violation, the water was shut off. It was shut off on August 17th of 2022.
Okay.
And this notice was sent August 31st. And I did not receive a response from either the tenants at the site address or from Carl Gaylor.
Okay. And at the bottom of the second page of that notice of violation, there's an admonition that, well, can you read the last two paragraphs, please?
Yes, failure.
Or at least, sorry, Ms. Wilkinson.
Yeah.
Just state generally what those say for the record.
So it says failure to resolve this violation or enter into a work plan or voluntary correction agreement within 30 days may result in the city assessing a civil penalty of $1,000 per day that the city documents that the violation exists on the property. Additionally, failure to abate may result in the issuance of additional notices, criminal charges, and additional civil or criminal penalties. Payment of a civil penalty does not relieve any party of the duty to abate the violations. This NOV is appealable to the hearing examiner as provided in BLMC 14.120.020 and BLMC 14.130.020. An appeal must be filed within 15 days of the date of service as determined by BLMC 14.130.050.
And Ms. Wilkinson, was this NOV appealed?
No, sir.
And just a quick question for me, so I don't forget. In terms of what happened in those instances, the second notice of violation, I mean, it appears to sort of update or augment the initial one, meaning they're not totally separate. To the extent, would it be an appropriate way to think about it that essentially the second one is an updated or revised violation notice such that they didn't have to separately appeal both documents.
Correct.
You see what I'm saying?
Correct. And by the time this second notice of violation went out, the window for appeal on the first one had come and gone.
But I mean, I guess I would understand. But for instance, in the first one, the city had said, there's trash that needs to be maintained. But then that's also in the second one, and not as a, civil penalty at that point. It's a notice. So it almost revived that as a potential.
Correct. It actually gave them another opportunity to appeal it should they have taken it. Yes.
Well, wouldn't it have given them an opportunity to abate the violation at that?
Yes, they had one opportunity to abate the violations listed in the first notice of violation, and then in the second one, they would have then had opportunity to abate them all again. If I'm understanding your question correctly.
Well, that's what I'm trying to understand. So, I suppose I'm just trying to think it through in terms of, I guess when you talk about, in Bonney Lake, documentation of each violation needs to occur. So, for instance, if trash is in both, is that two separate violations related to trash or not?
It's not $1,000 per violation. It's $1,000 per day that the city documents the violation. So had they cleaned up the trash, but the other 4 existing violations are still on site and there's no voluntary compliance, they would still be receiving $1,000 a day for having to go out there. So when I went to verify that there was no water and went back to the site, all of the prior existing violations were still there. Nothing had been abated, so they were included in the second notice of violation.
Right, but I guess my concern would be, for instance, if the city were to seek civil penalties on that first notice of violation, but then the second notice of violation it's a whole new notice of violation. They had, so maybe that's not what the process was intended to do here. I guess for me, it's not uncommon to have a updated or revised notice of violation, but it essentially replaces the earlier one. But you're saying that's not what happened here. I'm not saying it disappeared. I'm just, I understand that the water service issue happened, so you were adding it, I suppose.
Right.
I'm just trying to understand what the potential consequences would be, and this is because, we don't have others on the call. I'm just trying to understand that we all...
Right, and going forward, we could just do a separate notice of violation, but that would actually potentially incur more civil penalties.
And Your Honor, I think one of the things that my understanding is that the city has issued several notices of violation in this case as a way to provide additional notice, additional process to the defendant.
Well,
to the extent that there's a phone call to go out and investigate the property, and then maybe there's another phone call to go out and investigate the property again. Maybe there's 2 tracks here where, one is we're just issuing this NOV as a matter of process, and the other is we're issuing a second NOV because there are additional problems on the property that need to be addressed, and there has been an additional complaint about the property. That's something that we can, we might be able to talk about as the city's attorneys about what the best path forward is here going forward. But for
Well,
Like,
I'm, you know, in this instance, nobody challenged anything, you know, I mean, in terms of, you know, the city wanted in terms of the civil penalty, the notice of civil penalty was you know, assessed $3,000. Nobody appealed that, you know. So yeah, I'm just trying to think, you know, procedurally for the future. I can see I can see a potential problem, but if the idea is that, you know, all right, we sent out your NOV, then something else happened, and rather than have, you know, multiple tracks or multiple NOVs that nobody's keeping, you know, you know, we're gonna reset the clock on those violations that you hadn't addressed yet, and include this new violation in terms of, you know, your ability to you know, both comply or, you know, appeal. But you know, if the appeal period for the first trash thing hadn't passed, and then there's another trash thing, fine. But you know, I can see how that can end up problematic. But I'm kind of a non-issue here. I apologize. I'm just trying to.
No, I think it's good to talk about.
it is.
Um, they are listed under the same code enforcement case. And so there wasn't an additional case opened, and I think and I actually have it on my docket to talk to Ms. Robertson about, because as we all know, a lot of properties who are in violation typically don't just have, not all of them, but a lot of them, more things come up as we go on. And so how she would like that handled, I'll discuss it with her. I feel like in this instance, making the decision to do a whole new NOV rather than tracking two NOVs and assessing, you know, maybe $2,000 over here and $2,000 over here, it actually was a more reasonable way to check on all of the violations at one time instead of tracking different notices and different tracks of civil penalties. That was the thought and the intent. Well, I'll see what Mrs. Robertson wants to do going forward.
Sure, but to that end, I guess, you know, if I look at the notice of civil penalty, is it clear? Does it reference two different numbers, or the numbers stayed the same in terms of the violation number? You know, or you know, because like this is City Works 607. You know, so if I guess if there was no, if 606 didn't become 607, or 607 was the number the whole time, you know, there's clarity. I think I understand what you were doing, and I don't
Right.
think this is unreasonable at all. But, you know, I have certainly been in jurisdictions where the process is such that, you know, I can see where it would end up being highly problematic, to the extent that a lot of jurisdictions don't require anyone to document anything. It's just 1,000 a day for eternity, you know, or as long as they want, and then the jurisdiction might come in and go, well, we're gonna finally we're gonna finally try, and it's, you know, $800,000 in penalties for a, you know, 8,000 square foot lot or something, you know. So my point being,
Right.
that's not at all what you were trying to do. I just wanted to understand, were they totally different NOVs, different tracks? But no, it's all sort of the same process, at least in terms of this specific matter that we're dealing with. That an accurate way? It's, at least for this
Yes.
matter, this is all one process.
Yes.
You know, there's not some other process happening right now. Is important.
Correct.
Because I've had that happen many times too, where it's like, oh no, this is seems almost identical, but this was 4 days later, you know, and it's like, yeah, that can be a challenge. So
Right.
I think you've clarified it well for me.
Okay.
And
Good.
sorry to interrupt.
No.
I wanted to try to, you know, understand why there were the two, and one wasn't a correction or anything or a revision, but it did sort of subsume the earlier one to the extent that the city did not seek, two sets of penalties or anything to that end. Is that maybe a decent way to think about it?
Yeah, that makes sense to me. And they are, just to clarify, the civil penalties is listed under City Works 607, which is on full notices of violation. So it is all tracked under the same case number, just to clarify.
Got it. Yeah. Yeah. Okay. Yeah. Right. And even beyond, a little beyond the scope of what we were going to do today, but we had some time. So
yeah,
I think I understand the idea. So I think I get it. I think it's been clarified. Sorry to twist everyone around in thinking that through, but I think it was helpful for me to try to kind of think through the process. So
sure.
I interrupted your line of questioning. Did you have further questions?
I just have a few, Your Honor. So just to confirm, Exhibit 3 to the complaint, Ms. Wilkinson, is that notice of civil penalty, correct?
Correct. And that was also sent to Carl Gaylor at the Auburn address, as well as the current resident at 77th Street Court East. And that was sent on October 11th of 2002 for the amount of $3,000.
And how was that sent?
Based on my documenting the violations on June 28th of 2022, August 18th of 2022, and October 11th.
Or let me rephrase. How was that served on the defendant?
Oh, I'm sorry. Through
worries.
first class mail, per Bonney Lake Municipal Code 14.130.050 option 2.
And was there any appeal of that notice of civil penalty?
No, sir.
Okay.
There was no contact whatsoever.
And Ms. Wilkinson, are you familiar with the complaint in this case?
Yes, I am.
And how was the complaint served on the defendant?
It was so it was reported on title with Pierce County Auditor on February 13th. It was posted on site on February 14th, 2022. I'm sorry, 2023. And mailed first class mail and certified mail. Our code requires postage prepaid first class mail for BLMC 14.130.050 option 2, and option 3 lists the service by posting.
Okay. And can you confirm whether the property has water service?
So
now?
I had not heard anything from anybody regarding this property until about noon today on March 20th, 2023. They paid their bill in full, their utility bill, not the civil penalties, excuse me. And before I started, I confirmed with finance that was paid and will be turned on.
Okay, no further questions.
Thank you.
Great. And I don't have any, sorry, I do not have further questions as well. I guess the one thing and this is again a little more, universal or, and would relate to what we heard earlier as well. Some violations can de facto end up in a situation where if they are not abated or fixed, you end up with an uninhabitable dwelling and, no running water being one. Whereas, grass that's too long, I don't know what your code says about that, but some violations are not ones that will very quickly lead to that place. So I guess my question is, in these circumstances, have the other violations that are not explicitly being addressed, have they been abated already? I mean, or is it that the thing that would make it uninhabitable has been abated, but there's potentially the need for additional?
The latter.
Yeah, please, if we could have uh,
Yeah.
our code enforcement officer specific to these, and then you can make the legal argument if you want, Mr. Marchand.
So for the cash residents, nothing else has been abated yet. I will do some more research today. I did speak to an escrow company last week, and I believe the property is due to close tomorrow. And we told them that there are existing violations other than the water, and they have agreed to do a work plan for the things that they cannot abate by the end of the month. So
Really, I
going,
really opened up a can of worms for myself there, I guess.
you
But
did, yeah.
I
Um, so that's where we're at with that one. The Gaylor property, um, they brought pictures in, and the property has been cleaned up. I will have to check into garbage service if that was one of theirs. I'll have to check. Um,
was
and they need a permit for some of the work that was done, but we explained that to them when they were in here. I mean, they were here 15 minutes before we signed on talking about that stuff. So,
okay. So just to be
yes and
so
no.
well, and I'll let Attorney Marchand then address that to the extent that legally, on some level, I guess my role is limited, much more limited than I maybe realized, to the extent that I seem to be focused more on the specific violations that led to a complaint for a finding of it being an uninhabitable structure. But meaning, there was no challenge to the NOV, so one could say that those are severities, that those things were a problem. But I guess in your mind, Attorney Marchand, does it matter? I mean, is it that the any order I write should account for the potential for the city to go in? This would be the moment finally where they have the authority. I mean, they probably already had the authority, but this would be maybe the last step where they go, okay, if we got this far, we're gonna actually go pay, or have our crew go do it, and then we're gonna, have those costs fold in. I mean, what's the thought process, if you don't
And
mind?
I think here, because these two cases really are focused with, sort of laser like on the issue of whether the properties are fit for human habitation, um, and the water issue and the sanitary facilities issue. Um, I think the and Ms. Wilkinson, you can supplement this if from the city standpoint, if you care to. Um, I mean, the goal is always that the property owner abates themselves. The I believe the code, uh, puts the onus, the great deal of the load on the property owner to abate the nuisances, uh, rather than having the city get a warrant for abatement and enter onto the property and do it themselves. Um, so I think for the sake of these two cases today, um, Ms. Wilkinson has talked about sort of the path forward for both of these properties. Um, if and I'll ask Ms. Wilkinson, do you think does the city need a order for warrant of abatement on these, or would it like one, or are we
No, not
happy
at
to
this
just
time.
okay?
Yeah, I think they're separate issues. I think the unfit for human habitation is, we usually look at the structure. Does it have a roof? Does it have walls? Does it have sanitary facilities? So these ones, it would just be for the water, for the unfit human habitation. For these today, there is a separate. It would be a separate hearing, I believe, if we wanted an order for abatement to allow us to go clean up. That would be a separate.
Oh, Thank you. And I guess that was one of the things I was hoping we'd get clarification on, to the extent that certainly I understand that in various circumstances, the city seeks, costs, but in my mind, if there's a potentially further hearings in a different, for the types of, if all we're on today, right, is water, for the water, garbage, right? In my mind, unless I hear a better argument, the idea would be the costs that we're talking about have to in some way relate to this part of the process, and if they have outstanding fees related to everything else, I feel like that's a different track, unless I'm missing something. I mean, but I'm happy, this is, if I'm wrong about the way the code is structured, that's great. Every code's a little different, so I'm just trying to understand how that might work, And I'm happy to let I'll put that on the attorney, I guess, because I'm asking for a legal argument, I suppose.
Sure. Can you? I'm just trying to track
Let me give you an example. So
Yeah.
let's say that the property in question has violations A, B, C, and D, and A is, there's a junk vehicle, or two. B, that is on the property. No one's living in it. It's not super dangerous, but it is a violation of the code in most places. B is that they've got grass or weeds that are too tall or that have kind of maybe overgrown a little bit on the sidewalk or something. Again, not a structure that is gonna in any, it's not creating an uninhabitable structure. Still, it's a violation. And then C, though, is from as far as code enforcement could tell, the roof is caved in. It's pretty obvious from the photos, and then let's say D is no garbage service, So we've got these four, and that's the original notice, violation addresses these four, and says you have to fix these things. Usually the notice of violation doesn't immediately say that this is uninhabitable. It's, meaning that's a further process, but it can say it appears the structure's in violation, of the property maintenance code or this or that.
Sure.
And they could even seek some kind of temporary, order to ensure nobody's living there because it's potentially, but rather than going straight to the, potentially has to be torn down kind of situation. Maybe I'm making this too hard, but my thinking is that goes out. Even nothing happens, let's say, fine, they cut the grass. So then they've complied with one of the four, but they don't appeal. So then the city has documented the other three, on a visit. So, and then they send out a notice of civil penalty related to those three things.
Mm-hmm.
Then nothing happens. In my mind, the ultimate determination of the abatement being necessary, it's an unfit dwelling, that it's dangerous. I think to me that would, and at some point garbage service gets turned back
Sure.
on or something. But the junk vehicle thing is not in play in my mind. And so really what it is that part of the process, potentially even the violation about the roof. I think that's what gets you to this part of the process, and all the monies involved that you're seeking the cost would be this part of the process onward in my mind. And it doesn't mean that those outstanding costs and fees associated with code enforcement, the NOV part, couldn't be, sought in a different avenue. But I just worry that they can't be commingled, or maybe they can. I don't know the Bonney Lake Code well enough to have thought that all the way through.
And I think that they can. I think they can abate all of them, and they can be commingled, as you say, if the city is authorized to abate them. And I think the authority for that in Bonney Lake Municipal Code 14.130.150, which is abatement by the city. The city may abate a violation, including any resulting environmental damage, if one, the violation occurs on public right-of-way or city-owned land, two, a public safety emergency exists, or we have or there, three, a competent authority authorizes such abatement. And I think in this case, you would be the competent authority. This
I don't disagree with you in
Okay.
terms of abatement being something that can be, that can be used. But I guess in my mind, having something declared uninhabitable is different to me than asking for the ability to abate existing violations. Or does it not matter in this instance? While in Bonney Lake, I mean, are those two things totally separate? I don't know. That's what I'm trying to think through.
and
Can I ask a question? I don't know if you can answer this or not. Do you think, Mr. Reeves, that going forward, a separate notice of violation for unfit dwellings would be more clear?
I haven't thought it all the way through, and I don't want to muddle
Okay.
the waters here.
Yeah.
And I'm not, again, this is, we could, I guess this is partially why I wanted, in both these first instances, to have Attorney Marchant tell me exactly what the city is hoping to have me produce, given the change in circumstances that just occurred.
sure.
And rather than us think it through maybe all the way now, I'll come up with what I come up with for these two, and if it seems horrible, someone can ask for a reconsideration, I imagine, or appeal my decision. But the process can always improve one way or the other. I'm just trying to think through, and again, I apologize that I just didn't have enough time to really think through, especially given what happened in terms of, the change today. But and maybe I'm overthinking the concept of why one has a structure, labeled or identified as uninhabitable. Does it matter? Is it different? I think it is, but maybe I'm overthinking that.
And I think that, Your Honor, the purpose for focusing on the structure, I believe the municipal code prioritizes, prioritizes emergencies.
Mm-hmm.
The city of Bonney Lake prioritizes code enforcement issues as listed in descending order of priority. Number one, enforcement of life, health, and safety violations. So the reason we would have been seeking abatement, or an order for warrant, an order for warrant of abatement, would have been so that the city could, if the defendant failed to comply with the order of abatement, so the city could go in and board up a property and, keep people out of it if it's not safe to live in. I think in terms of, and I can provide this in writing too, but in terms of what we're looking for today, given that in this case and in the prior one, the sort of baseline condition for habitability has been restored. The city's not looking for an order for warrant of abatement. It's not looking for an order of abatement. It's simply looking for or looking to recover the costs of enforcement. So an order requiring the defendants to pay the civil penalty assessed against their property in such, and having that assessed against as a tax against the property value. Likewise, having as part of the cost of enforcements the reasonable attorney's fees that the city incurred assessed with that notice of civil penalty against the tax value of the property.
I think I understand the argument. I'll probably read the code more myself again more closely and decide and again, I have certainly not made up my mind on what the answer is because this is somewhat unique and the way I'm more often, I'll tell you out of experience, what I've had more often, in say Bremerton, I do a lot of code enforcement monthly docket, and you kind of have the code enforcement NOV process, and then after that's over, then they might end up having a very explicit, next process that is just abatement. And I'm not saying, I haven't looked closely enough at the code to think that through, sure, but they almost are tracking in different ways. I think the outcome ends up very similar. You don't get a double dip or anything, or you're not trying to find anyone twice. But I think I think the way you stated it is the abatement warrant of abatement in my mind, or specifically for the unfit dwelling, has more to do with a immediate, let's as soon as we can deal with the life safe, the health, the life. Yeah, how did you say it? I normally know how to say it. Issue, and then all the sort of fine issues is a separate process. But it doesn't have to be necessarily. I'm trying to think it through. I certainly need to look more closely. But if you can tell me again, in both cases, exactly what you were seeking based on,
sure,
where we're at, then factually, I know what's happened at this point, and
okay,
it'll be up to me, and it is what it is, and but I'm confident that, and again, in terms of the burden, I mean, there's no burden here. I mean, what is the burden to the extent that the city essentially said, we don't need this anymore. We're just seeking the fine. So is that, do you have to prove to me by a preponderance that fines are appropriate? That's a little strange in my mind.
So I think we're for both cases seeking a ruling that service of the NOVs and notice of civil penalty and complaint was properly done. That the defendants had notice.
I can make that
to respond. Sure.
And I'll include in my order, but I do so rule in both cases.
Okay. Second of all, we are not seeking an order for warrant of abatement or an order requiring the defendants to abate because they have taken care of the chief thing the city was concerned with, which is, the fitness of the dwelling, enforcement of life, health, and safety violations. Lacking running water is similar to a roof not being in, being ready to cave in,
sure,
in terms of the risk to the public or to inhabitants. So, while the dwelling is, while the defendants have taken steps to abate the nuisances or to abate the unfit dwellings on their premises, nevertheless, the city has incurred costs in bringing these complaints to you. It has incurred costs in you know, going out to the property to inspect, to issue the NOVs, the notices of civil penalty. They have incurred costs, certainly in hiring my law firm to
a lot more than hiring me, I'll tell you that. But
so what we're and
I understand the argument, Attorney Marshall. I'm gonna have to think it through. I'm not saying
certainly.
I'm not saying that I've decided one way or the other. It's just, you know, I'm gonna, and you know, I'm not gonna, you know, run up the clock as I think on these things, because this is for me, more of a meta issue that I'll ultimately have to think more on for what I think in the future. That said, as I requested, just tell me what you want. I think I understand why you want it. I think you're very clear in your argument. That's fine. I just need to look a little more closely myself and think it through. But it is helpful at this point to have kind of take out what was no longer needed. And again, don't you know, you can literally cut and paste, throw it together quick. I don't need another brief. I just really want to know, like, this is what we want, you know, at this point. That's all.
Okay.
And so I hope, does that cover it? And again, this was the first two that I've been involved in, and I haven't, you know, again, you know, don't do a ton of these in terms of the seeking the warrant of abatement. Often these are done in municipal court or some other higher up, as it were, elected person, not the lowly appointed hearing examiner. But I am allowed to do them, you know, under the law, and I just, you know, each code's a little different locally, not the state law, and so I just am going to do a little bit of research on my own and think it through, and we'll see where we end up. But my intent would be, you know, again, notice proper, you know. There was actually, you know, no challenge to the violations, as it were. So I think they're proven. You know, they're verities at this point. I think really it's just figuring out, you know, the money side of things and the next steps. And
sure. And
so I'll be as crystal clear as I can in orders that I produce in the next couple of weeks after I receive. And again, do you have I doubt it'll take you very long, because like I said, I cut and paste, but. Is there a time frame you were hoping to get that back?
I think
not my order. I'm saying what do you?
And Ms. Wilkinson, you can weigh in if you need, but I think in the next few weeks, if you have an order in that.
So I meant how long do you need to do the one thing I've asked of? That's
2 days.
Oh, there.
Yeah.
That's all. So my intent would be to produce something within a couple of weeks of the the record closing. That's all.
Okay.
And you know, but should be somewhat straightforward to the extent that, again, there's no major factual disputes at the moment. You know, and all the facts that ultimately needed to be proven, I have basically ruled have been proven. So I just, you know, I just want to think through the money side of it. And I will do so after I do that. So any final thoughts there from our code enforcement officer before we close the record on this one, or close our hearing? Okay, why don't we end our hearing and we'll stop recording. And I don't think anyone ever joined us. Nobody did. And we're just trying to wrap out